General Alberto Gonzales announced last month that domestic electronic surveillance will have to be approved by the Foreign Intelligence Surveillance Court, or FISA. This is co-hosted by the Center for Strategic and International Studies and the Heritage Foundation. It's 90 minutes.
On our heritage.org website and those today who are joining us via C-SPAN. We always remind our internet and television viewers that questions can be submitted throughout our programming, simply addressed by email to speaker@heritage.org, speaker@heritage.org. And for those in-house, please check that cell phones and pagers have been muted or turned off as a courtesy to our guests, and especially for our broadcast audience. We're pleased today to co-host this event with our friends from the Center for Strategic and International Studies. Initially opening the program will be Dr. James J. Carafano from here at Heritage. Dr. Carafano is our Assistant Director in the Catherine and Shelby Cullum Davis Institute for International Studies. He is also a Senior Research Fellow in our Douglas and Sarah Allison Center for Foreign Policy Studies. Most recently, his newest book is GI Ingenuity, Improvisation, Technology, and Winning World War II. But of more interest on our program today is his last Heritage book, which he co-authored with our former colleague Paul Rosenzweig on Winning the Long War, Lessons from the Cold War for Defending Terrorism and Preserving Freedom. I am pleased now to turn the program over to Jim. Jim?
Thank you all for coming. When Paul and I wrote the book Winning the Long War and coined the term Long War, we introduced this notion about that you fight long wars differently. That in long wars you're as concerned about retaining the capacity of the state to compete and thrive and prosper over the long term as you are with getting this enemy. This notion about doing both things equally well, that's essentially compelling and important in the strategy for any protracted conflict. And we introduced, what's a good long war strategy, and that's what we try to get at. And we introduced four kind of fundamental things that you had to do well. Obviously, security, both getting terrorists and protecting against them, sustaining and economic growth and economic competition, because that's what essentially allows the state to compete over the long term, protecting the civil liberties and privacies of your citizens, respecting those of your allies, and seeking human rights for all, because what allows the state to compete best over the long term is the will of the governed, and the civil society is the glue that keeps that together. And winning a war of ideas, all wars are essentially ideological struggles, and one in the minds of women and women. And what the argument that we try to make in the book is that you had to do all four things equally well. That you had to get the terrorists, you had to grow your economy, you had to protect the liberties of rights of your citizens, respect those of others, and promote human rights, and that you had to win the struggle of ideas. And that was the essential kernel of what the United States did well in the Cold War, and it was essentially what we argued that you have to do well in a protracted conflict or competition against transnational terrorists. And the remarkable thing is we got no pushback on that. Right, left, liberal, conservative, Democrat, Republican, everyone kind of nodded north-south when they read the book, or when we went out and talked to audience about it. It really didn't matter. And so you would think, having heard that, you would think that any time that there was an issue about what kind of security measures should we add, or how we should protect the liberties or privacies of individual citizens after 9/11, you'd have got a reasonable dialogue that people would say, yep, we understand the need to get terrorists and to protect civil liberties, so let's have a dialogue to talk about how we can ensure both. And actually, I think what you've seen is, quite frankly, is most often the opposite that happened. Is every time a new security measure is proposed, there are a chorus of critics rising up talking about how it's undermining the Constitution. And on the other side, anytime somebody talks about defending the Constitution, people rail about how you're trying to prevent us from getting the terrorists. And of course, the latest edition of that we saw was in national security agencies' role in intercepting and monitoring terrorist communications that flow across the world and in and out of the United States. And we had a long history of that, a debate over the controversy of the NSA programs, threat of legislation, some decisions by the United States to submit these programs under a court called the Foreign Intelligence Surveillance Act judges of the FISA court. So the question is now is what happened? What can we learn from this? What's going to happen on the way forward? Should there be more legislation? Did we do things right? Did we do things wrong? Why aren't we having this kind of reasonable dialogue between people about how do you achieve security? And and protect civil liberties. And so what we try to do is kind of have a dialogue here. And so I went out and found my two smartest friends. And it's not that Mary DeRosa and Todd Graziano are both Italian, which obviously makes them highly qualified to talk about anything. But I respect both of them greatly. Mary DeRosa is at the Center for Strategic International Studies, and Todd Graziano, of course, is here in our Legal Center at Heritage Foundation. So what I asked them to do was to go out and find two smart, intelligent, reasonable people on this issue and come together and have a dialogue to see if there is a consensus of reasonable people who wouldn't want to start out with a debate about security versus civil liberties, but want to start out with the notion that both security and civil liberties are important, and see if there's a consensus among reasonable people about what happened in these programs, what have we learned, and what's the way forward. And so what I'm going to do is I'm going to turn it over to Mary first, and Mary's going to offer some remarks, and then she's going to introduce Susan, her guest, and then Todd will say some remarks and introduce his guest, and then we'll get done. We'll have a directed discussion among Mary and Todd on the panel up here, and then we'll bring the audience in as well, and we'll do some question and answer, and I think we're going to end about 11:30, so we should have plenty of time to kind of flesh these issues out and give everybody an opportunity to participate in the dialogue, and we'll see what we learn at the end of the day. So again, thank you for coming, and you're not just bystanders here; you're participants in this exercise of democracy, and so I look forward greatly to hearing what we can learn on this, which is still a very, very vital issue. So, Mary, the floor is yours.
Thank you, and I hope I can live up to your hopes for the.
Well, you're Italian, so you've already.
Well, I'm not sure if that qualifies me for being reasonable. I'll speak first, and then I will introduce Suzanne. I think the reason we're here, most of the reason we're here, is to look forward and talk about what do we do now. But I think you have to separate the issues of how the national security, the surveillance policy. Called the terrorist surveillance policy was authorized and how it has been handled up to now, and then looking forward. I have strong disagreement with the way that it was authorized and the way it's been handled. I won't be able to resist making a comment or two about that, but I'll try to then talk more about what I think we need to do next. On the looking backward part, and I just note that the recent move by the administration to bring the program under the authority of the Foreign Intelligence Surveillance Court to get court approval of all of the surveillance decisions under that program. I think it underscores the important point that this was never about necessity. The administration's decision to go around FISA, violate FISA, go outside of the scheme that FISA set up for approving these was not about a national security imperative. It was, there's no question that using the FISA scheme is a big pain, very difficult. I think that that it was at best an inconvenience, but it was not impossible, because if it's possible now, it was possible earlier on, and I think that that's just an important point to keep in mind, to the extent that legal arguments were made and on the basis of this was an imperative and this was necessary for the president to carry out commander-in-chief responsibilities. I think it's clear that was not the case. What I wish the process had been, is to really look at the statute, the FISA statute, and examine carefully for what kind of flexibility and what kind of opportunities there were within the statute to do what was needed. Keeping in mind that I have not been in the administration, I'm not privy to any of the classified information or what is actually happening in the program, and so I'm basing any understanding of what's happening just on public reporting. But what I believe, FISA is much more flexible than a lot of the discussion since this came out has given it credit for. And I think what has happened with the statute and with, as with many other statutes, I think in the executive branches, you have years and years and years of interpretation of a statute. So you've got the statute and what it actually says, and then you've got sort of layers of policy and caution and lore that have for all of with the best of intentions and for good reasons built up around it, and you have lawyers in the different agencies telling policy people they cannot do things when maybe it's not really the statute that says they can't do things. So what needed to happen, and what I think clearly has happened now, is trying to peel away those layers and find out what you really can do under the statute. And I think that it is and was more flexible than it was given credit for. So that's my backward-looking comment. What to do now? I say that the FISA, the statute, is a lot more flexible than people have given it credit for, but it is far from perfect. It is far from a model of clarity, and I think there really are, in the right thing to do is take another look at it and change some things, modernize it, make it make more sense. You obviously have to do that in a way that's responsible, but I want to sort of go through some of the things that I think might be a useful part of a modernization of the statute. Because, and I should say as background, I think almost everybody agrees with me that surveillance, electronic surveillance of terrorists and for purposes of fighting terrorism is extremely important, critical, and we don't want to have ourselves hindered in our ability to do that unnecessarily. On the other hand, extremely intrusive, very sensitive area. We're talking about interception of the contents of communications, and we have to be extraordinarily careful about protecting privacy and liberties. So I'll just sort of tick through a few things that I think might be useful to update, modernize the statute. One, I think that it's important at this point because of what we have, the discussions that we've had and the way that the terrorist surveillance program was authorized, is to have in a statute a reaffirmation that the process that is set forth in FISA is the exclusive process for authorizing national security electronic surveillance. I think that what we have now, because there's been no action on the part of the Congress to respond to the administration's legal arguments, you have the danger that that they will be seen as having acquiesced by this administration, by later administrations, perhaps by courts, and in my view, the exclusivity of the FISA mechanism is just really critical. In an area as sensitive as this, outside court oversight of decisions about electronic surveillance of U.S. persons and within the United States is really critical to public acceptance of this kind of tool. Beyond that, outside oversight provides an incentive. I mean, I think the perfect example is the fact that the administration has now found a way to get the court to approve and get this program under the court's authority within the FISA scheme, is that without a check, without somebody from the outside looking over your shoulder, the executive branch with the best intentioned personnel are going to find it hard to take all of the really necessary steps, to the hard work that it takes to find a way to do something that is less intrusive but get you where you want to go. If you have, the recent switch shows that it was impossible until there was scrutiny from outside, and then it became possible to find a way to do it. So I think that is another important thing that you get, and I'm sort of stating the obvious, but that's what checks are all about, outside checks, and having it be a court that is the FISA court that is doing the approvals, I think is so important for public acceptance of the decisions and of the process in this extraordinarily sensitive area. What else might be updated? I think any legislation that looks at the Foreign Intelligence Surveillance Act and process has got to deal with some of the bureaucratic issues that we hear about all the time. I'm not convinced that I'm convinced, in fact, that most of the bureaucratic problems are not because of the statute, but certainly if Congress can give the executive branch a hand in working out this, this really sometimes crippling process, they need to do it. Whether it's more, and a lot of the legislation that has been proposed in this area, almost all of them have some fix for the bureaucracy, whether it's adding people or other kinds of streamlining. And so I won't spend much time on that, but I think that's really quite important. Modernize the statute, or the technology discussion, the way the statute talks about technology. This is a statute that was passed in 1978. It's been updated a number of times, and things have been added, but it dealt with a world that looks very little like the world that we live in now in terms of technology and the threat. So, you look at the statute, and although I've said that I think it's very flexible and you can read it, you need your decoder ring to figure out what on earth the statute is really dealing with and how do you apply the intent of the statute in 1978 to current circumstances. So I think that we could really benefit from updating to make the language of the statute more technology neutral, more it fits our current needs, but maintains the very important protections, the core of the protections that the Act and the balance that the Act has had from the beginning. I think one example of where the changes in technology have caused confusion, and one thing in particular that might would profitably be clarified is that right now there is at least some confusion about whether when you have a conversation or a communication that's taking place entirely overseas between two people who are overseas, but the interception might be taking place at a switch in the United States because of the change from circuit-based to packet-based communications, and I'm not a technology person, so I've now exhausted my ability to explain that. But in any event, we now might have a situation that we would never have contemplated in 1978, where a communication entirely overseas would be actually intercepted within the United States. I don't think FISA intended to cover that. I actually do not believe the current statute would require that communication to come under the FISA mechanism, but there's at least some confusion about it, and I think that's a place where we could modernize and fix. I should mention, I read an article yesterday that by Kim Tai-Pal that's going to be coming out sometime soon that does a really good job. It's called The Era of Dionysus, Rethinking Foreign Intelligence Surveillance. It will be coming out in the Yale journal. And I just found it very helpful. I don't agree with everything he said, but he sort of goes through some of the changes to technology and how they raise issues with FISA. I thought it was very helpful. And that's the kind of discussion that I think really would be profitable. I think, finally, I'll just mention that we need to find a way to deal with automated analysis programs and how they fit into electronic surveillance and the approval for electronic surveillance. I think link analysis, traffic analysis, what some people call data mining, an inexact and loaded term, but automated programs that use algorithms to detect terrorists and to determine subjects for surveillance. Again, not something contemplated in 1978, an important tool, but a very potentially intrusive, dangerous to privacy tool, and we need to craft a way to have careful court oversight of the tools without having some sort of broad brush approval of an entire program and then come back and see me in 45 days. I think that's not enough to really give a rigorous look at these things. You need, and I think a court could, within its appropriate role, look at a process, look at an algorithm, see how accurate a particular process will be, what is the trigger for human actual review of communications, what kind of protections and guidelines are used, what kind of audit or other monitoring, and to have careful and regular oversight of those programs. That's something I think that it really would be a good thing to have in a modernized FISA. So I'll stop there with those few ideas, and I'll introduce Suzanne Spalding. Suzanne has a very distinguished career in national security and intelligence, and she's been on General Counsel for the Senate Intelligence Committee. She's been Minority Staff Director for the House, for the HPSCI. She's been Executive Director of the Deutsch Commission and the Bremer Commission, a lawyer at CIA. She's past chair of the ABA's National Security Law Group, and I could go on. So I will introduce Suzanne, and you can continue.
Thanks, Mary. It's probably not surprising, given that Mary was the one who asked me to be on the panel, that I agree with virtually everything that Mary said, and I will try not to be repetitive as I talk about this. But one of the areas in which I agree with Mary is that we can't just start with today and look forward. I think it is important to review the bidding up till now and to have some more discussion, debate, and work at achieving some consensus about the legal framework and what has happened to date, as well as where we want to go as we move forward. So in that context, I think it's important to look again at the legal posture of the terrorist surveillance program. And again, I think it will be important for us to reach some sort of understanding about what that legal posture is and what it ought to be. As you know, the administration justified the terrorist surveillance program in its operation outside of the context of FISA and inconsistent with the requirements of FISA on really basically two grounds. One was that it was authorized by Congress when Congress passed the authorization for the use of military force after the attacks of September 11th. And the second was that it was justified was pursuant to the President's authority under Article 2, primarily the Commander-in-Chief authority, because we are engaged in this global war on terrorism. I think it's fair to say that most scholars do not accept, and I'll just speak for myself, I do not accept that the authorization for the use of military force can be viewed as an authorization to ignore the very clear requirements of FISA and the language in FISA that talks about it being an exclusive means. The language in FISA that contemplates a situation where we are at war and provides specific authority for 15 days of warrantless surveillance in that context. A very detailed, very complex law, many pages long, worked out between Congress and the executive branch, passed by Congress, signed by the President, to conclude that that was somehow in effect overruled or repealed or altered by this very brief authorization for the use of military force, which makes absolutely no explicit mention of electronic surveillance or even intelligence gathering, or certainly FISA. I think is not only inconsistent with common sense, but is not consistent with traditional concepts of statutory construction. So I think that argument falls, and then the president is left with relying upon constitutional authority under Article 2. And I think clearly the president then is operating in Category 3 of Justice Jackson's 3 categories described in the steel seizure case. And you'll remember that was the case during the Korean War when President Truman acted in violation of a congressional statute in seizing steel mills in the United States, and argued that it was essential to do that in order to ensure the production that was necessary for the defense of this nation. The country was at war in Korea at the time. Congress had enacted a somewhat elaborate statute which provided a process by which the government could assert priority in the production of steel at steel mills. And the president said that was too cumbersome and really shouldn't apply in time of war, and asserting constitutional authority seized those steel mills. The court ruled against the administration in that case. And Justice Jackson, in a concurring opinion, talked about this tension that is inherent in our constitutional system between the president and the Congress, and the relationship between them in 3 categories. There are 3 situations in which this can come up. The first is where the president is acting in concert with and consistent with a statute that Congress had passed. So when the president is acting pursuant to FISA or pursuant to this statute that allowed the president to take over the steel mills under certain procedures, etc. In those situations, Justice Jackson said, that's when the president's power is at its greatest. I think that's one of the things that's so ironic. That's where the president's power is greatest. It's not where the president is asserting the authority to act unilaterally, but where the president is acting in concert with Congress, because the president now is acting with all of the president's authorities and all of the authority of Congress combined. Second category that could come up is where the president is acting in an area where Congress hasn't spoken. Congress hasn't done anything on this. The president is asserting authority to do it. Justice Jackson says that's kind of a gray area or a twilight area, and you have to look at the Constitution and do an analysis and figure out, does the president have the constitutional authority to act in this way and in this area. The third category is where the president is acting in contravention of or against the implied or explicit will of Congress. And there, Justice Jackson says the president's authority is at its weakest. That's not where we have the most powerful president. That is where the president's authority is at its weakest. Because the president has to be arguing not just inherent authority, which is the term that's often used, but exclusive authority. The president has to be arguing that Congress has no constitutional right to speak in this area, and that the president has constitutional, unique, exclusive constitutional authority in this area. That's the category in which I think the president was acting under the terrorist surveillance program. Now, granted, Justice Jackson did not say the president has no authority to act in contravention or against the express or implied will of Congress. Justice Jackson could have said, the president can't do that. Justice Jackson didn't say the president can't do that. But it's a pretty narrow category and a very high threshold to meet. And I would argue that in this context, we don't know. We don't have enough facts to know whether the president was operating in a constitutional manner on the day that the president first said, go ahead and conduct electronic surveillance in violation of the Foreign Intelligence Surveillance Act. I could posit a circumstance in which I would think that would be constitutional. Under any circumstance, the president has to be operating consistent with the Fourth Amendment. There's no circumstance under which the president can ignore the Fourth Amendment. I don't think the administration would argue that. I don't think anyone would argue that. So the Fourth Amendment says that that any search has to be reasonable. And we have court cases that have said the way you establish whether it's reasonable, and particularly in the national security context, is you look at the government's compelling need and you balance that against the nature of the privacy intrusion. So that's why we would need to have the facts in order to be able to second guess that decision on that day. But certainly you can posit a circumstance, you can envision a circumstance where this would be something has come up in a context that Congress could not have contemplated, did not contemplate, in the passage of the Foreign Intelligence Surveillance Act. That it is an emergency situation. Time is of the essence. There's no time to go back to Congress and try to get the law amended. And the President has to act in order to defend or protect the nation. I think it's not unreasonable to say that the President retains some exclusive authority to operate, to act in that circumstance, to say to his people or her people, go ahead, conduct the surveillance. I would argue that at the same time, the President needs to say, and you, legislative affairs folks, go down to the Hill and start talking to Congress right now about how we can put this on a more solid legal footing. And why is that? It's clearly from a policy perspective that makes a lot of sense, and I'll talk about the national security implications of not putting this on a more solid legal footing, because I think there are, in addition to privacy concerns, there are real national security consequences for having failed to do that. But it's also, I think, part of the Fourth Amendment analysis, that balancing. Part of the compelling government need here is urgency. It's time. It's that there is no time to go to Congress and get an amendment to the law before you conduct that surveillance, because we have to do it right now. Over time, that element on this side of the scale, government compelling need, dissipates as you have time to go to Congress and see if you can't seek amendment to the legislation. And that doesn't mean, running it by a couple folks up on the Hill who say, oh, I think it would be too hard. I don't think that qualifies. And so I would argue that 4 years later, 5 years later, that's going to be a very hard argument to make, that you're still within the bounds of the Fourth Amendment in terms of being able to argue that compelling government need. Certainly today, I think, it was incumbent upon the administration to bring this within the scope of the law, either, as they appear to have done, working out a way to conduct this program within the boundaries of the Foreign Intelligence Surveillance Act, or by seeking amendments to the law. So, and I think that's important. I think it's important to review that and to have that in our heads as we move forward on this, and as Mary says, not to just sort of leave that hanging. Because I think the alternative is the administration continues to assert unilateral authority to decide which laws it's going to abide by and which laws it's not going to abide by, without really giving us any clear indication of where the limits are on that analysis. Under what circumstances, and under what circumstances can the President not decide that this law, unilaterally, that this law unconstitutionally infringes on my authority, and in a secret, very secret way that I hope never comes to light and therefore can never be challenged in court, I'm going to ignore the law and go ahead and do what I want to do. I think that's an extremely troubling place for us to leave this. So I think it's important to resolve that issue. I'm very pleased and encouraged that we are now at a place where apparently this program has been brought within the bounds of the Foreign Intelligence Surveillance Act. And it has been brought before a judge, and there's some kind of orders, and there's so much we don't know, and there's so much we probably never will know about this program, and there's so much we should never know as members of the public about this program. But based on what I have heard from administration officials and others, it sounds as though this program has been brought within the bounds of the Foreign Intelligence Surveillance Act. And I will tell you, I am more confident in congressional oversight today than I would have been a year ago, not only because we have the tension that I think is sort of healthy between the differing parties in the White House and Congress, but also because there's some indication from what we're hearing that there's greater transparency with Congress, that in fact Congress is learning more. The fact that the administration has agreed to hand over the orders issued by the FISA judge, apparently, to the Judiciary and Intelligence Committee, at least to the leadership, I think is encouraging, that they're briefing those members. That's important. And if I have a sense that they know what's going on, and that they are comfortable that this is indeed complying with the Foreign Intelligence Surveillance Act, frankly, that's good enough for me in terms of a sense of whether we're on some kind of more solid legal footing or not. I don't know whether the legal theory is based on anticipatory warrants, which were, recently upheld in a court decision. I think there's an interesting discussion to be had there about how that might apply here, whether it's looking at minimization procedures that have changed. Kim's article that Mary mentioned speculates that a lot of this is about collaterally collected information, incidentally collected information, not the information you were targeting, not the person you were targeting, but information that you happen to collect while you're targeting a legitimate target. We don't know what that is. And I think, again, as I say, to some extent, we aren't going to know a lot of this stuff because there are national security imperatives for keeping it secret. But I do think there's an awful lot of this that we can discuss and need to discuss in a public forum. I agree with Mary that I think it's very likely that FISA needs to be updated. And I disagree with those who say we can't go there because any discussion about any legislative amendments to FISA will reveal such sensitive information that it will just, significantly damage national security. I'm sure those arguments were made when FISA was first enacted. And those definitions of electronic surveillance are convoluted and extremely hard to understand for a reason. I mean, they were dancing a very delicate dance. They were trying to bring as much transparency to this process as possible, which is important in a democracy. For intelligence activities to operate in a democracy, it's really hard. You have to roll up your sleeves and you have to bring as much transparency as you can in order to maintain the public trust. And I think they worked really hard on doing that in FISA, and I think they did a very good job. And I think it may be time to look at it again. But particularly in light of all of the amendments in the PATRIOT Act and the way FISA has become not just the electronic surveillance statute. I mean, early on, years ago, it included physical searches, and now it includes all kinds of authorities in the intelligence realm. It's become the statute that governs intelligence collection inside the United States. And I think Congress ought to convene a joint inquiry. It ought to have, at a minimum, representation from the Judiciary and the Intelligence Committees. I would consider even including the Armed Services Committees, given that DOD is engaged in intelligence collection inside the United States. And I would look not just at the terrorist surveillance program, but other programs which the Attorney General has at least hinted are going on. And I would look broadly at our domestic intelligence collection effort. What are we doing? What have we done? What should we be doing? What do we want the government to be able to do? And what is the appropriate legal framework for domestic intelligence collection writ large? So I would do a much broader review of this, and I would do it in some depth, and then make recommendations to the appropriate committees and to Congress. And I'll leave it at that, because I think I went too long.
Well, thank you, Susan and Mary, for beginning this discussion. And I'm going to try to limit my remarks somewhat and yield extra time to my guest, John Yoo. But given that James has reminded you all of my Italian heritage, I hope he will understand that I must begin by wishing my mother happy birthday. An Italian son has to devote his efforts on his mother's birthday to her happiness. So happy birthday, Mom. Now, turning to the topic. I just want to give a few brief remarks, my sort of legal overview, and some of this is in response to what Mary and Suzanne, and then give a sort of extended introduction, not just to Professor John Yoo, but to his writings, which I think are the key to the right, providing the right dialogue on this subject. Let me just define a little bit more for the public that may not remember what the terrorist surveillance program is about. It was a program after its most horrible leak to the New York Times and other papers, which would intercept calls from suspected Al-Qaeda or allied terrorist organizations abroad when they called across the border to suspected allies in the United States. During the war, of course, we've captured laptops and other material with cell phone numbers. It isn't, of course, probably raise probable cause to believe that everyone they're calling in the United States is one of their cell members bent on the destruction of the United States. But we are at war. At least I ask you to accept my belief, and I think easily defensible position, that we are at war, and at war, identifying who the enemy is an important goal. Well, I wanted to comment just a little bit about what the legal framework for that kind of a program is, because I agree with much of what particularly Susan said, but with a few exceptions. And that is that the FISA statute may not apply at all to that kind of a program. I know there are arguments. I won't go into details about that. But I will remind everyone that FISA was written for a Cold War situation, not a shooting war. A Cold War situation where the identity of possible Soviet spies, who they were, was reasonably well known, and someone could go to court. It wasn't a shooting war where the paramount need in a shooting war is to identify if they're saboteurs, who the soldiers are, and if they're, particularly if they're saboteurs in your country. But even beyond that, FISA always had unconstitutional aspects. Every president has pointed out that it has some constitutional applications, and it has some very unconstitutional applications. And if you push it to apply in a shooting war, then those unconstitutional aspects dwarf the constitutional aspects. This president has been extremely restrained in not pointing out the not pushing the obvious, that it has so many unconstitutional applications. He has tried too hard, I believe, to live within the questionable constitutional regime. And I worry seriously that he has done so. But with regard to that, I do want to say that I beg to differ that the authorization for the use of force did nothing. In that respect, you know, Congress always speaks, or often speaks inconsistently in different enactments. It seems pretty clear to me that when Congress says, with regard to this war we're fighting with al-Qaeda, you are to use all necessary means to defeat al-Qaeda and similar terrorist organizations, that one of the absolute requirements that Congress is requiring him to do, is to find out who they are. You can't direct energy at the enemy unless you determine who they are. I appreciate Suzanne's discussion of Justice Jackson's opinion, but I'd now like to just suggest that Congress has great power during times of war. If it uses its own power, it can defund a war, it can not approve military commanders, it can do all sorts of very interesting things, which John has written so brilliantly about. And private citizens who have their Fourth Amendment rights violated, the courts are open. The courts have all sorts of roles to adjudicate those. But there's just a few things that I submit the president clearly does have unilateral authority, and I think it's not fair to say that the president purports to decide which laws he will follow and which ones he doesn't. He has an absolute constitutional obligation to guard his own constitutional power, not just for the benefit of the citizens, which is the immediate need, but also for the benefit of future presidents. And that is all he has done in a very modest way. I'm going to pose a few questions at the end, but now I do want to spend some time talking about John Yoo, and I'm even going to give a short, brief introduction of who he is. He's to talk about some of his writings. He's professor at the University of California, Berkeley School of Law, known as Bolt Hall, and he's been a visiting professor at many distinguished universities, both here in the United States and abroad. John has worked in senior legal positions in all three branches of the federal government, and the position that probably gives him the most relevance today was when he served as Deputy Assistant Attorney General in the Office of Legal Counsel in the Justice Department. And this is an important office that advises the President and other cabinet secretaries on constitutional issues. Well, Professor Yoo's expertise was international law, foreign policy, and separation of powers issues relating to war powers and treaties and those sort of boring subjects which prior to 9/11 were not going to be important issues in this administration, concentrating on domestic issues. Well, as you all know or should know, after 9/11, John was forced to be one of the central legal scholars that helped the administration figure out what the legal regime allowed or even required the president to do to fight the war that we're currently in. And I think he's done a brilliant job. Subsequent to some of the leaks, however, John has unfortunately been a subject to incredibly ignorant attacks by some conspiracy theorists and cultish movement automatrons who unfortunately don't have much of a clue that their grasp on the facts and the law don't have much link to reality. But fortunately for the rest of us, especially those who know Professor Yu, he has written all these great books in recent years. And I want to just mention two briefly, because I again do think reading John Yu's law reviews and books, particularly these two that I have here, will do a lot to provide the sensible dialogue that we need. Those who know Professor Yu know that he is one of the most brilliant, but also civil and open-minded scholars who writes on issues of war powers. His book that came out, I think now about 2 years ago, The Powers of War and Peace, particularly concentrates on the historical and constitutional issues that from our founding generations, or actually well before the founding, how the war powers can correctly be understood that were incorporated in the Constitution based on British and colonial constitutional history and the constitutional practice since then. Well, of particular relevance today is his most recent book, War by Other Means, which focuses on a lot of the legal issues he worked on for the administration. And in particular, he's got about 8 chapters, 8 subjects that he deals with. Chapter 5 deals with the NSA's terrorist surveillance program. I'd like to read 2 brief excerpts, though, to just talk about how difficult a job and how valiantly John has done it. In response to some of the leaks about the terrorist surveillance program and a profile that the New York Times did on him subsequently, somewhat, I think, accurately and somewhat most clearly inaccurately, John wrote this: Justice Department officials have prohibited me from responding directly to accounts in the New York Times and in other papers. They say that to discuss any aspect of the program or my involvement could reveal sensitive national security information that has not been publicly confirmed by the government. While this rule makes a great deal of sense, it has the perverse effect of giving leakers an advantage. Government leakers will reveal only selected information that places them where their interests in the best light possible. And I should add, and they may not even be true. Even if the media publishes incorrect or misleading reports, those who follow the rules cannot respond because the government is concerned that any confirmation or denial would reveal secret information. Well, John, in his chapter, has done a great job of using the publicly released information from the Justice Department, the administration, and his own knowledge just of the legal issues and facts in explaining the need and the proper legal regime for the terrorist surveillance program. I wish he could tell us a little bit more. But there's an even more, I think, important point he relates in his introduction, and maybe you could elaborate on, John. He says in his discussions he finds a lot of misunderstandings about the facts and law relating to our war with al-Qaeda, but he adds this: I also found that many people have an exaggerated view of the role of law. Law is critically important to our society generally and to the war on terrorism. But the law is not the end of the matter. Indeed, it is often the beginning. And so this is my first question to all the panelists. I think that we do see an unfortunate legalization of policy disputes. Matters which are really policy issues being termed as legal issues. And I wonder if that isn't in part intentional, because people are avoiding the more difficult policy. Congress, instead of exercising its authority that it has to defund a war, wants to accuse the president of another party of violating the law. My second question, principally for John, is whether the change in legal foundation that the TSP is now being run, I suppose, recast in, will calm the political and other questions about it. I think it raises more troubling ones for me, and it relates to my last question. And that is whether the supposed supervision of the FISA court is constitutional, or in what ways it could be constitutional, because we don't know exactly what the FISA regime is all about. And I want to end with the following hypothetical that I think John has heard before, but I'm not sure some of the rest have. Could Congress pass a collateral damage bombing court and say that, 15 days after any war begins, every military commander shall go to the collateral damage bombing court and get approval for their bombing missions? And I think it would be correctly said that certainly the president would have time to go to Congress to get such legislation. And certainly we could make it an expedited process. Would that be constitutional to require the president to go to judges to get approval for bombing? And if not, is intelligence gathering more like bombing or more like something else? John?
It's unfair if Todd asks a long question I'm still trying to write down and then to ask me to start speaking. It's a great pleasure to be here again at Heritage, and I'd like to thank Todd and James for inviting me, and Suzanne and Mary for appearing on the panel. I'd like to say, if it's not obvious, that I'm not Italian.
But your name isn't a vowel.
I am, in fact, Korean, however, and we like to think we plan farther ahead than the Italians. So I'd like to wish my mother a happy birthday, too, but it's not for several months to come. I'd also like to thank Todd very much for that very kind introduction. The only fact I would leave that he left out is that both books are very attractively priced and available at local bookstores near you. They're not the usual $100 academic tomes. We were asked to try to find common ground on the terrorist surveillance program. And so before I try to answer Todd's questions, which I think probably the other panelists will want to answer too, I'm going to try to identify some areas where we might agree, and then maybe point some way forward. I think everybody seems to acknowledge it to some level that the FISA statute is not in its current form really the best tool or suitable for the challenges of the war on terrorism. Right? The FISA statute is a 1978 law written primarily to allow us to better watch Soviet espionage agents. The primary enemy was thought to be a nation state. So some of the criticisms of FISA have to do with just the change of technology, which I think are correct. But I think one thing that was missing in the earlier presentations is that part of the pressure on FISA's obsolescence has been caused by the fact that the enemy is different, right? That it's not as easy to conduct FISA-style surveillance when the enemy doesn't conveniently locate most of its espionage agents in your country in its embassy, which the Soviet embassy provided. The people working there was the convenient first starting point to look for people who are contacting the Soviet Union. If you have an enemy that has no territory, that operates like a network, that does the best it can to blend its activities into the activities of the civilian population, and then tries to conduct surprise attacks on civilian targets, then you have to use different measures. The FISA framework really wasn't built originally to address an opponent like that. The other thing about FISA, which also makes it somewhat unsuitable, is that it brings, and this is, I think, really Todd's point, is that, and I'm just going to take a step back and sort of abstract it a little bit, is that it uses this law enforcement framework to approach what is increasingly becoming a military problem. Right? So the FISA system, one of its reasons it's so attractive to lawyers, and lawyers like it a great deal, is it's very comfortable. It's very similar to the criminal justice system. You go to a judge, you get a warrant, you conduct a wiretap, you get the warrant because you can show probable cause that you think person A is a terrorist or connected to terrorism. right? But that doesn't necessarily work in the war on terrorism. So, for example, just take a hypothetical about something that could not work under the FISA system, I think, at all, but which would be a very sensible thing to do right after 9/11. And again, I can't say whether we actually did that or not. I hope we did, but I don't know whether it's technologically possible. But suppose after 9/11, the United States could intercept every communication going in and out of Afghanistan, right? We knew the Taliban were there, we knew the Al-Qaeda were there. I would think that would be a very sensible thing to do. You could not do that. You cannot do that under FISA, right? Because FISA requires that you already have a reason to think that a specific person is a terrorist or connected to terrorism, right? It doesn't allow you to do a blanket search for all communications going in and out of the country. And to make it even more perverse in terms of the war on terrorism, under FISA, we could intercept all the communications going from Afghanistan to other countries that didn't involve Americans without a warrant. But it would be harder to intercept communications from Afghanistan into the United States, right? I think under the current statute, if there's a call coming out of Afghanistan into the country, you have to get a FISA warrant. You would think those would be the ones you would be most worried about, right? Those are the ones that you would higher level of scrutiny to in the weeks after 9/11. And I don't think there's any way to rewrite the FISA statute in order to bring such a, I think, which would be a very sensible thing to do under the into the FISA statute and the FISA system as it's currently written and currently designed. I think Todd and I have serious disagreements with the other two panelists about the constitutional framework that governs this area. I think, for example, the others on the panel think that Congress has sort of the dominant role here and that the president really ought to be implementing Congress's policy decisions. I think Todd and I draw on a longer tradition in American history of presidents carrying out national security surveillance. So just one, I think this is an objectively true fact that it doesn't come up very often, which is that President Franklin Roosevelt ordered national security surveillance and did it much more broadly than President Bush has. He ordered in May 1940, over a year and a half before Pearl Harbor, there's interception of every communication inside the United States or outside the United States, regardless of whether anyone was suspected on either end of the call of being linked to terrorism. He just wanted all communications intercepted because he was worried that there might be Axis spies or sympathizers in the country who would blow up munitions plants, in part. At that time, there was a Supreme Court decision and a federal statute which prohibited any wiretapping by the government without a warrant. So it seems to me, if you want to talk about direct conflicts between the presidency and Congress and between over national security wiretapping, happened back then. The Attorney General at the time even went to Congress, talked to members of the House Judiciary Committee about passing a law to approve the program and was told no, Congress would not pass such a law. And President Roosevelt said, okay, I'm going to keep doing it. Now, today we tend to associate President Roosevelt with having successfully waged World War II. And in fact, today I think most people are glad of the things he did before World War II to make the entry of the United States into the war quicker on the side of the Allies. I think under a vision of the Constitution where Congress is dominant, you would have had a lot of difficulty for President Roosevelt to get the country into the World War II and take those steps that are necessary to help the Allies. That said, I think there is agreement that signs of congressional support are important and welcome. And in part, putting aside the constitutional disagreement, I don't think anyone disagrees that it would be important as a political matter if people in the public thought that certain people in Congress who had been briefed on the program thought that it was legally okay as a matter of assuring the public that even though they can't know the details and they wouldn't want to know the details of the program publicly, that it has the confidence of the leaders in the intelligence committees and so on. I think that sign is already apparent from the courts, although we could talk a little bit more about this discussion. I'm still not clear how it is the court actually approved the terrorist surveillance program. And I think Mary makes a good point there, which is if the court could approve it now, why didn't it do it 2 years ago? The only thing I can say is that either the program has changed in its scope, which is entirely possible, or the judges on the court have changed. Because it seems apparent as a political matter that if the executive branch could have gotten a FISA court to approve it 6 years ago, they would have. I don't think they just sort of blindly go about doing things on their own for no good reason. The last thing is, what can we do to look forward in terms of changes to the law. One thing I would say is that the debate about FISA and the debate about the PATRIOT Act, which most people don't know is mostly just hundreds of amendments to FISA, in a way they obscure the debate because I think people who are very critical of the administration's approach to civil liberties and terrorism, I think tend to exaggerate the importance of the terror surveillance program, of the PATRIOT Act, and of FISA. They make it seem, I'm not saying actually that Mary and Suzanne have done this, but in other fora, you see people saying this is the end of civil liberties in this country in wartime, where I think most people who look at these programs and look at the PATRIOT Act, look at FISA, see them as evolutionary changes in this sort of basic FISA framework, but nothing revolutionary, right? Nothing revolutionary, the type that was mentioned before about data mining, for example. I think if there was more data mining, which most intelligence experts would tell you is the one thing the government is prohibited from doing right now, which would be a big change in the capabilities of the government to go after terrorists. But there's a funding restriction on research and development by the Defense Department into data mining. That would be revolutionary, big change. That's not mentioned in FISA. That's not mentioned in the PATRIOT Act, and that's not a part of the TSP program as far as we know publicly. On the other hand, people who are very supportive of the administration's programs tend to, particularly in the administration, tend to exaggerate the importance of FISA and the PATRIOT Act. And I don't think they are as important as some people think because they aren't revolutionary efforts to try to get at terrorism. They are evolutionary modifications of the basic statutory framework. So one thing I think we need to do going forward in a useful way is to think seriously about whether we need to whether the FISA system should still continue to govern the way we think about intelligence gathering, given that it's rooted in a 1978-based system of a law enforcement approach to handling national security threats. If the threat that Al-Qaeda poses to the country is much greater than what espionage and what small-scale terrorism had thought to be earlier, then we ought to, I think, reasonably expand the tools and capabilities we're willing to bring to bear to stop them from carrying out more successful attacks on the country. And I think in order to do that, we have to rethink the legal system to match the deployment of new kinds of capabilities. So one example I think is a good example. How do we use data mining? Should we use some kind of statutory method? Is this somewhere where the executive branch should take the lead? Right now, I think our system is so mired in this debate about FISA and the PATRIOT Act that we can't really come to grips with data mining, which really is something significant and revolutionary that we could do. How do we use new technologies? Again, are we going to allow the executive branch to go first to develop them, or are we going to look to Congress to establish the rules for new technologies? The one thing I would caution, and this gets, I hope I can answer Todd's first question here, is about the legalization of all these disputes is, I think, somewhat unwise in this respect. Law makes a lot of sense, and using very clear legal rules makes a lot of sense when you have a lot of experience with the costs and benefits of certain actions, when you know that certain policies produce certain kinds of costs and benefits consistently. The thing it seems to me you don't want to do is pass strict or clear legal rules when you're still trying to figure out exactly what the policies are. Right? It seems to me you wouldn't pass a law about data mining before you know exactly what data mining can do and all the associated benefits and problems with data mining. It seems to me you wouldn't legalize this area of intelligence gathering, especially with regard to Al-Qaeda and terrorist groups and these new kinds of technologies, until you have some substantial experience to draw on what works and what doesn't work and what you want to do and what you don't want to do. And so with that, I would say, in answer to Todd's first question, I agree. I think this whole area has been legalized. In a way, I think the legalization of it, the fighting over the law, does tend to obscure the policy debates that one ought to be having about whether, for example, data mining is good or not, whether, say, intercepting all the calls out of a country makes sense or not, whether we want to have harder standards for when those calls come to the United States or not, how do we protect privacy interests, we could do that using technology or not. So I quite agree with Todd. I think it's a very insightful question that, because we're probably all lawyers, we tend to like talking about it in the framework of law, but then you don't really have a good upfront discussion of what things we could or could not be doing for the future just based on their positive and negative costs and benefits.
Thank you. I want to be respectful of everybody's time, so I'm going to ask in a second how many questions we have. So you can be thinking now if you have a question or not, because we have about 25 minutes left. Before I do that, I want to ask two questions of all our panelists, and I'll give you a thing. The first question I want to ask is, is obviously everyone on the panel thinks that the current FISA law is inadequate and they'd like to see it revised in some way. So that's for different reasons. So that's one thing you have in common. But the first question I want to ask you is, each of you, is what do all of you think that you have, what are the points that all of you think that you share in common? And then when we're done with that, I'm going to come back and ask you a second question. The second question is what do you fundamentally think that you most disagree with among the four of you? So let's be positive first, and we'll just go down murderous row. We'll start with Mary. And so, what are the points of policy and law that you think that everyone at the table shares in common? And I'd like each of you to address that.
Well, I think the answer to the second question is probably longer.
Yeah.
But I think there are some things that we agree on. On the question of confusing legal and policy issues, I think that we probably have some agreement on that. It concerns me a lot that when discussions about what should we be doing get turned into discussions about can you or can't you, and I think this happens a lot of times for the best of reasons when within the government, when you get told you can't do something by a lawyer, when really it is more of a policy discussion. So I think that separating out policy from what should we be doing from what we can and can't do in a discussion is always a good thing, and it doesn't happen enough. So I think we agree on that. I think we actually agree on the importance of flexibility for the president. And I disagree with the characterization that John, you made of Suzanne and my remarks that we think Congress has, well, I won't speak for Suzanne, but at least I do not think that Congress has the dominant role here. I think Congress has a role here. I don't mean to be morphing these answers, getting into a disagreement when I'm talking about agreements, but it sort of amuses me sometimes when I find myself in these discussions, because I was a legal advisor at the National Security Council and have always considered myself, or since that time, somebody who really believes strongly in executive authority. And then, since these guys came on the scene, I realized that I'm actually not as strong in that area, not as extreme in that area as I thought I was. But I do think the president's authority is very important in these areas. I disagree about the degree to which FISA and other things constrain it, but I'll get to that in the second question.
Suzanne?
Well, once again, I agree with Mary, and I won't repeat it. But I think another way in which I think there's some consensus here is that there is some real value in operating on a solid legal footing. That there is, from a policy perspective and a public faith and trust perspective, some value in trying to work through these issues in a legislative context, or at least bringing as much transparency to the policy discussion as we possibly can. And I want to just take a second to talk about why I think that's important from a national security perspective. Why the failure to put this program, the terror surveillance program, on a solid legal footing from the get-go had national security implications. And I think there were several very, very real implications. One was that the program was leaked. And if you support this program and you think it's important to national security, and that its leak harmed national security, well, part of the reason that this program leaked was because there were individuals who knew about the program who thought it was illegal, who did not believe it was on a solid legal footing, and felt compelled to go public with it. If it had been on a more solid legal footing, I think it's far less likely we would have had that public exposure. It was shut down for several weeks. So again, if you think the program is important, the fact that it was shut down for several weeks, and as I understand it, I mean, from what little bit we can glean from reading between the lines, it was shut down for several weeks because of debates about the legality of the program or legality of certain aspects of the program. That, again, I think if you believe the program is important to national security, harmed national security. it certainly demoralized, I think, to some degree, the intelligence community, certainly certain elements of the intelligence community that now feel some uncertainty about the legal footing upon which they're operating, and in this context, potentially facing criminal prosecution if a court decides to rule on this and rules that it was, in fact, in violation of FISA. Every individual engaged in that activity faces personal criminal liability. And then, obviously, the future support of Congress for things like the authorization for the use of military force, which is obviously, I think, important for national security, that Congress be willing to give the President the kind of authority that the President chooses to seek from Congress is jeopardized when a program like this is not on solid legal footing. So that's my reason, but I think while you may disagree with those particulars, my sense was there was a consensus on the value of having these activities operate on a more solid legal footing.
Okay, I think I've come up with 6. I hope I agree. 1, we're in a real shooting war. This is war. 2, we have a desperate need during a war to find out who the enemy is and for other valuable military intelligence. But it's even more important where we have terrorists in our country trying to destroy us through terrorists. 3, we agree that it would be very good if national security secrets could remain secret. 4, FISA is very, very problematic. We disagree as to how problematic. 5, it would be nice if Congress would do the really right thing and fix FISA. I'm a lot less optimistic about whether it's certainly not worth it to agree to change FISA if it's not a good fix. So that's where. And 6, we all agree that the President has some inherent exclusive constitutional authority. I think we disagree on what it is, but I'm going to offer one that I hope we all agree on, and that is, since time immemorial, it is not just the power but the obligation of the Commander-in-Chief and every military commander in the field to gather any and all military intelligence about the enemy.
Well, I agree with what Todd said. I have a shorter way to say it, which is, I guess the question is, Congress has already authorized the President to use force. Under the Constitution, the President has the authority to use force to repel outside attacks. Why would the President be disabled from learning the information where to point the gun when he already has the power to pull the trigger? And I think that's basically what we're talking about, is that the President's constitutional authority to use force to try to kill the leaders of al-Qaeda has to carry with it the authority to use all the methods he can to find out where they are in the first place. I think we all agree on FISA. I'm going to try to answer James' question more directly, because everybody's been saying we ought to change FISA, we ought to amend FISA, without being very specific about exactly how they would change FISA. So one question I would have is, would people be willing, as I would be, to allow FISA to extend to the surveillance of targets not based on identity but on based of place or on the basis of the type of conduits that's being used? So, for example, when we say probable cause that somebody is likely to be connected with terrorism, we have some percentage belief that that person is in fact connected with terrorism, but it's not 100%. Maybe it's 50% or 30% likely someone's connected to terrorism. Well, would people instead be willing to say, will we allow FISA to extend to surveillance of a place where we think it's 10% likely terrorists will be using this communication channel? Will we allow FISA to allow for a sweep of all communications coming into and out of Afghanistan, because we think if they're people, or Western Pakistan, because if we think they're terrorist leaders of al-Qaeda, they're likely to be in that area? The second thing I would say is whether FISA, and I think it's just something Todd said earlier, whether we ought to also think about changing this sort of judicial, going to a court and getting a warrant in order to conduct surveillance model, which again comes out of the law enforcement area. I think another useful change would be to say, look, if you use FISA, then you can take the evidence you get from this very judicial-centric process and use it in criminal prosecutions in federal court. And that if you don't, if you do, I think as Todd has suggested, and the President is using all the methods he can to get information to stop an attack, and he doesn't go through this judge-centric process, whether you just simply say, okay, if that leads to information that stops an attack, good, but if it doesn't, okay, but you can't use that information to try to convict someone and throw them in jail. That all you can use it for is for the military purpose of trying to stop an attack on the country, and can't be used for any other collateral purpose of prosecution. which is really what I think maybe it was the Fourth Amendment and its restrictions of the other Bill of Rights connected to it are designed to do, is to place restrictions on what the government's doing in terms of the criminal justice system, not trying to place rules on the way we conduct military operations.
Let me ask you now if you would each comment on what you think you all fundamentally most disagree on, and just give and if you could be brief. But when we'll start with John, and when everybody else's answer, if you don't like John's FISA law, you could use that as your example. But John, we'll start with you, and we'll just work the other way very quickly.
Well, I think the thing we clearly all disagree on the most is the constitutional framework. I know Mary said I'm not trying to portray Mary and Suzanne as pro-Congress in any way, but, when they say that, I think, Mary, you said the first thing you said you would do to FISA is to say, make it clear in legislation that this is the exclusive mechanism for the president to gather intelligence inside the United States or on U.S. citizens abroad. And if that's the case, and if the president has to obey that, that seems to me pretty clear that the Congress has the ultimate policymaking role and the president has to implement it. I think Todd and I believe that there's a certain sphere for the president's constitutional authority, and Congress can't take it away. Just like Congress could not take away the president's ability to make tactical, strategic decisions in wartime, or with his suggestion of the court, the president could not subject discrete military decisions, like targeting decisions, to some other judicial process or some other branch of government. There, I think the simple question in my mind is, and this is the one we fight over, is this part of the president's commander-in-chief power? If it is, as the lower courts have said, then Congress can't take it away. If it's not, then it is more open to regulation by both the president and Congress together.
I want to elaborate on the same point that I think there is disagreement. I think that the best change in FISA would be for Congress to admit, to understand first, and then to admit that the president's military intelligence surveillance, as long as he's really, by the way, if he uses supposed military intelligence to gather dossiers on people, he would not have the protection of his military commander-in-chief authority, and he and other people in the executive branch could be both impeached or criminally prosecuted. But to the extent that he's really engaging in military intelligence, that the FISA courts or no court has any role. That would be the best change, and I think we disagree on that. And on that point, I'd like to just say that since no one has yet talked about my bombing hypothetical, I think I'm going to conclude with my bombing hypothetical. It doesn't matter even if the president thinks that he's willing to go along with the collateral damage. It would be unconstitutional for him, and mostly it would be unconstitutional for a court to be involved in that sort of process. When the framers gave the president the authority to fight tactical battles, it also incorporated within that the responsibility to engage in military intelligence unimpeded by the political branches.
Well, I think that is the fundamental area of disagreement, which is the constitutional posture of this and the scope of the president's commander-in-chief authority and how it applies in this context. And I was going to take up your hypothetical. Your question, is intelligence gathering more like bombing or like something else? I think in the context of this conversation, we really are asking, is electronic surveillance of Americans inside the United States more like interfering with bombing decisions overseas or something else? And I would argue something else. I do not think that it falls into the same category as telling the president where to move a particular battalion of troops. And I do think that the president has some broad authority with respect to intelligence gathering overseas for foreign intelligence purposes and for military purposes. But the reason that it gets so complicated here and why it is so hard, and we've talked about this for so long, is because the global war on terrorism is not just like World War II or even just like the war in Iraq. And that has very significant and real implications for policy as well as for law. And so when you're talking about using the commander's Article 2 Commander-in-Chief broad authorities in this ill-defined global war on terrorism where the enemy is ill-defined, and the scope and duration is hard to gauge and potentially goes on for generations and generations. I think we have to be very careful, and it is very different from the war analogies that are often used.
Mary?
Agree completely, but I'll just say one other area where I think we kind of fundamentally disagree, and that is about what FISA does. Because in the discussion from John and Todd, it sounds as if FISA cuts off the president from conducting surveillance. That FISA does not take away the president's ability to conduct surveillance. FISA is a mechanism for conducting surveillance. It regulates it. It says you do it a certain way. It doesn't take it away. And so I think that the characterization at some point of we all agree that FISA is very, very, very problematic. I think FISA could be improved, no question. I don't think it's very, very, very problematic. I think it is a good structure, and it correctly balances the liberties and security, and it provides the president an ability to conduct electronic surveillance. It does not take it away.
Have a show of hands for questions. All right, and if you would state your name and your affiliation, and if you'd ask a brief question, and if you direct it towards one panelist, because we only have about 6 or 7 minutes, and I want to try and squeeze in as many questions. We'll start in the middle there.
My name is Brian Beery. I'm a reporter for Europolitics. My question is for John Yu. Just about the usefulness of, you seem to be in favor of some blanket ability to electronic surveillance. I mean, how useful would that be? You mentioned the analogy of Roosevelt, but, after having that blanket surveillance for a whole year, wasn't the United States taken by surprise in Pearl Harbor? So surely he should have known about that then. And wasn't the lesson from 9/11 that you really need to depend more on human intelligence and not to rely on technological forms?
I think that's a fair question. I'm not trying to pretend that if we expand electronic surveillance, then the world would be perfect and we would be able to stop and detect all future terrorist attacks. Just, I think one can't say, right, that Roosevelt, the Roosevelt blanket interception of all calls would have stopped World War II if it were really effective. All you can do is to think about things you can do that decrease the probability that the enemy is going to succeed in an attack. And so obviously increasing the other human intelligence would be important. The other thing that FISA was changed in the PATRIOT Act, which was very useful, was even though we had all this information within the intelligence community, they weren't allowed to share it all in one place because we had various walls built up between different parts of our government because of the way the bureaucracy and the courts interpreted FISA. And so that actually was, I think that's a useful thing that's changed. It could use some more work. But I do think that again, turn this hypothetical, a blanket interception of all calls and emails going into and out of Afghanistan, I can't say stop any following terrorist attacks, but it certainly had to have helped the government get more information on the location of the enemy. So I think your question implies that I'm promising some kind of holy grail of a solution to terrorism, which I'm not. It's just something that would be more useful and more helpful.
My name is Marty Fega. I'm not a lawyer, but it seems to me that this is a debate about warrantless or warrant search. And in the situation that we face, we have to have both. I mean, I don't know anything about the TSP, even though I know a lot about classified intelligence matters. But I think it starts with a bunch of phone numbers that you pick up in Iraq. You capture people, you get cell phones, you get hard drives, you have phone numbers. One of those phone numbers calls me. The FBI says, well, what's this about? So they listen, and they may find, well, it's Marty buying a ring for his wife. So what happens now? Hopefully the record gets destroyed. On the other hand, maybe the call sounds pretty suspicious. Coded words, but suspicious. Now it would seem you could get a warrant. I don't object to the fact that first communication was intercepted without a warrant. Nobody could know who the parties were going to be. And yet it's essential to start the chain to finding the actual terrorists. Those of you who are lawyers, I'd be interested in your view of that.
Maybe Mary or Suzanne would.
Well, as I hear the example, I think you could get a warrant for that first under FISA, which I think people sort of make it make FISA much more of a hurdle than it actually is. I mean, I think if you've got if on one side of the conversation is somebody who we think is a terrorist, we know is a terrorist, probable cause to believe is a terrorist, then it's just not that hard, my understanding, to get the authority to intercept that communication.
Okay.
Yeah, if I could comment.
Sure.
I think it's a very sensible question, and I think many of the other critics of FISA would say that first intercept both can't be obtained unless it goes through FISA, and that on just the minimal facts you mentioned, all the phone calls that someone over in Afghanistan makes probably don't satisfy FISA, at least in some number of situations. And I want to just maybe take exception to one thing that I think Suzanne said about this being such a different war. Certainly it's a different war in some respects, but identifying who the enemy is, who the loyalists are, who saboteurs are, is an endemic problem since Greek times. In American Revolutionary War, the Civil War, we had saboteurs in World War I, we had saboteurs in World War II, but especially if you look at George Washington as a spy master, identifying who were on his side and who wasn't is an endemic problem with war. And when they gave the commander-in-chief authority over that, that's a different legal regime than that which we're normally used to in the Fourth Amendment. And it is a serious mistake to apply the exact same rules to the evidence that's admissible against a citizen in a criminal trial and the military commander's obligation to identify who the loyalists are and who the saboteurs are.
In an effort to end on time, I'm going to ask, I'd like each of our panelists to ask her one last question, which is, if I put the four of you in a room and asked you to write a new FISA law, could you? And if you could tell me yes or no, and maybe just a sentence or two, why or why not, and then we'll end on that. So we'll start with John and work our way this way.
It depends how much you're willing to pay me to sit in that room. I wish I could charge as much as a private lawyer for that. I think it's possible we could write some change into FISA about the probable cause standard. I think there are proposals to lower that so that's easier to get a FISA warrant. I also think that perhaps there could be work in FISA done to if this is what people want to do, is to recognize some authority for the commander-in-chief to act in certain situations without a FISA warrant. I would say we wouldn't be able to agree on prohibiting the president from doing that, but there could be recognition of times when Congress will be supportive of certain situations like that and not require a judicial warrant process to engage in surveillance.
Great question. I think with these two wonderful scholars, we could come up with a safe harbor. We might disagree on when the president has constitutional authority to go around it. We might disagree on whether that statute would claim it's the president, the exclusive authority the president has. But we might agree that that's something we could live with and that we could create some safe harbors. Unfortunately, I'm not sure some of the critics, I could write a statute and get agreement with some of the current leading critics of FISA who really, I think, have some more fundamental misunderstandings than my co-panelists.
Could the five of us go in a room and write a new FISA statute?
Well, not me, because I ain't a lawyer.
Yeah, well, that's all right. They don't have to be a lawyer to write laws. Lots of members of Congress aren't lawyers. Too many are. Could we? Of course we could. Should we? Absolutely not. And this is my point. I don't think we should be trying to guess at what it is that is causing problems under FISA, or guess at what it is that the administration, what kind of technology they want to be able to use, what sort of technology they're facing in the adversaries, et cetera. People who have done that factual inquiry, who know those details, who really understand where the rub is with respect to the current legislative framework, are the ones that ought to sit and write that law. And we ought to participate in the policy discussions to the extent that we can, and I hope that that is to a great extent. But should we write the law? No.
I'm just going to agree with Suzanne.
Okay. Well, please thank with me in thanking our scholars, and please come again. Thank you very much.